appeal in the matter of Martin George David Clements-Siddall and Dunbobbin Hotels Ltd.
Yes, may it please your lordships. I represent the appellant, George Clements-Siddall. I'm assisted by my learned junior, Chloe Murray, who sits behind me, and the respondent is represented by Mr. Neil Block. Your lordships, this appeal proceeds on the basis of written permission granted by my learned Lord Justice Stuart-Smith.
Yes.
My lords, this appeal relates to an incident that befell the claimant's mother on the 1st of January 2017. I'm sure your lordships are aware of the basic circumstances. Can I just check, first of all, that you have all the documents you need, save for what's been requested recently?
Yes.
So we have two bundles, a core bundle, which is a short bundle of some 70-odd pages, and a supplemental bundle, which
just
again,
hang on a minute.
Forgive me.
I thought I had two screens. I've got three, and everything is appearing over there, which is not quite where I want it.
Ah. I understand your lordship is
Yep.
the only one who has the electronic version of the engineering evidence, which has been requested. Is your lordship coming to proceed?
Whatever the end of that question is, the answer is no. But let's go on.
I'm obliged. So, your lordships should have a core bundle and a supplemental bundle, and on its way, as requested yesterday in electronic form, obviously that was sent.
Yes.
The engineering evidence.
Yes.
I have an instructing solicitor who is outside, making frantic phone calls to the Owen Mitchell office here to see if someone can be there to print the documents, and they will be brought as soon as they possibly can.
My clerk's got the electronic version. Why don't we just get him to print them?
Are they already doing that?
They're in the process of doing it.
But if it's being printed in the building or nearby, fine. But if it's being printed in Manchester,
no, no, my lord. It's being printed in the offices here. It's a 10-minute walk, possibly less by taxi.
Okay. Well, we're not going to get to them for a few minutes.
That's fine. Thank you.
So, my lords, this appeal relates obviously to the incident of the 1st of January 2017. The basis of the appeal is in two parts, essentially. First is that the learned judge below did not take into account the fact that the parties had agreed an important fact in the proceedings about the location where the claimant's mother fell. The defendant's position is that there was no such agreed fact, and I will deal with that in my submissions, my lords. The second part of the appeal essentially is on the basis that, irrespective of the court's failure to consider the agreed fact, the findings of the judge are challengeable. Rarely, I understand and I accept, is it possible for this court to challenge findings of fact made below. But we submit that the findings that were made did not follow the appropriate course. They did not follow the evidence that was given. Too much weight was given to evidence which was very unreliable, as found by the judge. And the claimant's evidence, the claimant's mother's evidence, was supported in a very fundamental extent by her husband's evidence, Mr. Siddall. And he was not cross-examined about what he said about the circumstances of the accident. But if we get that far, my lords, I'll expand on the second part of the appeal. We make a submission, a general submission to start with, my lords, that the parties are encouraged at all stages to narrow issues. And that is what was done in this particular case by those who instruct counsel. They agreed in a case summary a pertinent and very important factor. So, my lords, the supplemental bundle contains the case summary. And I'd like to take you directly to what we say is an agreed fact. Well, it's page 3, divider 2. We'll just, it's there already. 1.3, it's agreed between the parties, paragraph 9 of the particulars of claim, paragraph 7 of the defence, that the upper section of the raised decking area was between 720 millimetres and 725 millimetres. And there were hooks on the wall to the right of the jacuzzi which were intended for spa users to hang their robes. My lords, I will take you to photographs to make this more easily understandable. And I will come back to these agreed facts. 1.4, the single witness account of the fall is provided by the claimant's mother. The exact circumstances leading up to and how the fall occurred are in dispute. However, it is agreed that after using and exiting the jacuzzi, Miss Clements fell from the raised decking area. My lord, I will seek to persuade you that the reference to the raised decking area is not an issue which was in doubt between the parties.
Well, it's not. It's clear on line 2 of line 1.3. The raised decking area
Indeed.
is the same raised decking area as the end of 1.4.
Yes, that's what we say. That's what we say.
What's the date of this document? Do we have?
It's shortly before, it's not dated, my lords,
No,
but
it
it's
isn't.
shortly before the trial.
Okay.
In the normal course of events, the parties have to prepare a case summary for the trial judge.
Yes.
And it was a document that was negotiated over a period of time between the solicitors. I understand there was significant correspondence that led to this. It frequently happens, my lord, that a case summary is not agreed and 2 case summaries are put before the court. But there is no doubt we submit that this wasn't agreed case summary. As my learned friend made the point in his skeleton argument for the trial below, if one looks to page 26 of the supplemental bundle, this is Mr. Block's skeleton argument for trial. Paragraph 3 at the bottom, my lords, there is an agreed case summary.
I just looked at 1.2 of the case summary, which I hadn't focused on before, and that begins by saying that Ms. Clements and her fiancé used the jacuzzi, which is positioned in a raised area of decking. And then 1.3 talks about the upper section of the raised decking area.
Yes.
And then 1.4 says fell from the raised decking area.
Yes.
And you say that must be a reference back to 1.3, not 1.4. 1.2.
Well, my lords, in fact, it relates to both. And let me take you to the photographs, which may assist you more. I still have a general point about the importance of agreed facts, but I'll come back to that, my lords. It's helpful to look at the general photographs. So if I can take you, first of all, to some photographs of the spa. If you look at divider 13, the page numbers are very faint, but for your lordship's notes, they are 235. Give me 236, 237. So that's the spa. The steps are marked there, but there are better photographs. 238 divided 14 provides you with a better photograph.
The difference between 235 and 238
Yes.
is the right-hand set of steps.
Indeed, my lord, yes. That was an addition.
Could we just have final confirmation? Were the right-hand steps there at the time of the accident?
Yes, they were.
So 235, 236 are, while being useful in many respects, are misleading as to the extent of the steps.
Yes, indeed.
But the handrail stayed in the same place,
The handrail stays in the same place.
as we can see in 238.
They're useful for one other purpose, my lord, the older photographs, because they show the hooks on the white wall to the right of the jacuzzi.
Yes.
where it was eventually accepted that visitors to the jacuzzi were intended to hang their robes there. And therefore, it was intended that visitors would stand on that right-hand side, which is the raised decking. So, if your lordships could look at 238.
Two, three, three.
238, my lord.
Thank you.
You'll see a photograph indicating the modern stairs. You can see there's actually a slight difference in colour between the right hand and the left hand stairs on the other side of the rail. And where there is three bushes, the hooks have been removed, but there are three bushes on the right raised decking. A better photograph, 239. That shows the right raised decking. It's not in the condition it was at the time of the claimant's mother's accident, because those plants are positioned there. And then if we were to look at the next page, divider 15, page 240, my lords, this is an extract from the defendant's engineering expert, Dr. Lemon. And your lordships will see that Dr. Lemon has identified the raised deck area, which is the raised deck area in question. The measurements that I referred to, my lords, of 700, a dispute between the experts of 720 millimetres of height or 725 millimetres of height, refer to that raised deck area.
So to be clear, the raised deck area doesn't include the first bit coming from the water. It's where there's a step up to that bit with the plants. The raised decking is that
Yes.
bit.
Yes, my lord. Dr. Lemon, for the defendant, was entirely correct in identifying that particular area.
Yep.
And my lords, when you see the joint statement of the experts, you will see that there's no doubt that is what they're referring to. And then, for good measure, there is a photograph that the claimant produced identifying her location of fall pre-accident. This is a pre-trial. This is an attachment or an exhibit to her own statement, page 198, divider 8.
Sorry, divider 8.
Divider 8, and
Yes.
page 198.
Thank you.
The X and the arrow indicate the claimant's case as to where she fell from. If one considers that, and one considers Dr. Lemon's document at 240, or photograph with his markings upon it, we submit that it's clear what the claimant's case was, and it's clear what raised deck area meant to the litigating parties. But there is more that will support that contention. Well, having taken you to the photographs, can I just go back to the point I was opening with the importance of agreed facts? Because we deal not in an inquisitorial process, we have an adversarial process. And once parties have agreed certain facts, the importance of that is that they are essentially removed from the trial judge's jurisdiction. The judge is no longer seized of that issue. And we submit, however it happens, that parties may not focus on an agreed fact. If a fact is agreed, it is agreed, and the judge cannot overturn that or take any other role in it, unless the judge explicitly were to give permission to a party to resile from such an agreement.
I might as well just raise this now. I have a general understanding of why you say that.
Yes.
Neither party has cited any authority on the area that you've just mentioned, but there must be authority on it as to where. This is assuming that you established that it was an agreed fact.
Yes.
At the beginning of the trial. There must be authority about when and in what circumstances and how a party can withdraw from that agreement, whether it's effectively withdrawing from a concession or whether it's just simply an agreed fact.
It's a point, my lord, which is of real interest because we have assumed that this is such a straightforward point that there's no need to refer to authority. We can look for an authority if your
Well,
lordship.
speaking entirely
like
for
this.
myself, we have read Mr. Block's cross-examination of your client.
Yes.
We've read the closing submissions.
Yes.
And certainly speaking for myself, that raises a question about how and in what circumstances a previously agreed fact, if it was, comes back into the judge's jurisdiction is the word you've used.
Yes.
Particularly, if I may say so, given what you said.
Indeed. Well, I will attempt to explain how we got distracted. We, and I include the judge in the we, got distracted from the agreed fact. But we were distracted from it, without a doubt. But if there is a...
But is it your position, is it Mr. Block's position, that you've looked for authority on this point, or you think it's so basic it doesn't need authority and haven't looked?
Well, it's the latter, but we will look. But we have looked in the White Book. There is nothing in the White Book to assist us. There is a procedure for a resiling from an admission, which is an analogous procedure. So very regularly in this type of litigation, an insurance company will make an admission of liability, and then subsequently, upon investigating the facts, will realise, actually, that was perhaps too generous, and seek to resile from the admission. And that procedure has been formalised, and it has to be made by application, and a judge has to adjudicate upon it.
For my benefit, for my note, can you just tell me where we find that?
We'll look for it. Give me.
In due course.
There's no such procedure that we find in the White Book for agreed facts. But it's become a well recognised, quite a lot of litigation and authority on the point of resigning from admissions, because all sorts of issues of fairness and timing come into play.
But it's pretty close to an admission, because even Mr. Block would, well, I think he did accept. I'm sorry, I don't mean even Mr. Block. Mr. Block did accept in closing submissions, sub silentio perhaps, that if your client fell from the edge, the raised edge, he had a problem with guarding.
Indeed.
He didn't admit it, but anyway, it's obvious to anybody.
It's obvious, yes, it is.
My lord, I'm not appealing.
What?
I'm not appealing that finding.
No. If you're not appealing the finding that if she fell where she says she fell from, as shown in the thing,
Yes.
you're not appealing the finding that in those circumstances the judge would have found you to be liable.
I'm accepting
Yep.
the judge's findings on the lack of guarding.
That's a slightly different point from the one that I was making, which is that it's obvious to anybody engaged in this sort of litigation that if she fell, then you had some explaining to do, or you had a case to meet.
I've now looked, I'm sorry, at 3.1 of the issues in dispute, because I'm still wondering whether raised area, raised decking, and so on, what that means. And 3.1 sets out what are the issues in dispute.
3.1, my lord,
Of the case summary.
Yes.
So, sorry, that seems to be critical. And they've got opposing views about the departure from design plans, adherence to building regulations, installation of the raised decking area without a safety barrier,
my lord, yes.
and the right-hand steps. I don't see an issue as to location, or am I?
No, my lord, you're right. The issues in the case, and I will take you to the issues, but briefly to give a forewarning of where my submissions are going, the issues in the case were, number one, the raised decking was not slippery, therefore the defendant was challenging the claimant's mother's assertion that she slipped on the basis of potentially asking the judge to make a finding of contributory negligence. Because if her account was she slipped, but they proved she couldn't have slipped, then she must have fallen off the edge or stumbled off the edge. And pursuant to Section 1.7 of the Congenital Disabilities Act, it is possible to allege contributory negligence in this type of situation.
But we don't have even a contingent ruling on contrib.
No, we don't.
In the event that you succeed on liability.
No, Lord, there's no such finding. No.
Which may need to be considered if, in other respects, we're in your favour.
It may need to be, my Lord, but if we get to that stage, I'll address you on that point, certainly. But the points that I'm making is the issues before the judge below were, is it slippery in the context of contributory negligence, and this raised decking did not need a barrier. That was the issue raised by the defendant. Our engineering evidence suggested that the British standard guidance was that any raised platform with a potential fall of over 600 millimetres required guarding, and the learned judge accepted that proposition. And this is, by any view, over 600 millimetres. As the defendants say, it's 720, and we say 725.
Can I just go back, sorry, to the point my Lord raised, because I think we sort of, you're going to look for cases as close as possible to the issue raised by this case.
We're going to look, my Lord, for cases that deal with agreed facts,
Yes.
where a party has
Rather than
attempted to-
admissions.
Yes.
Yeah,
yes.
okay, thank you.
But we have looked briefly, so I didn't say that we've looked, we felt it was such an obvious point,
I understand that.
but my understanding is that there may not be any cases
Right.
that are similar to this. But we will double check. Can I go back to what was the agreed fact? Because we've dealt with it in some ways, but there is more to assist your lordships. So we've got the case summary, which Judge Lord Justice Lewis has identified, 1.3, 1.4 and 3.1. But if one looks at the pleadings in this case, pleadings are in the core bundle. You can see what the parties were discussing. In the particulars of claim, you'll find that document divided 11, and the defence conveniently divided 12, and we'll be flipping between one and the other. Paragraph 9 of the particulars of claim, well, I'll start with paragraph 8, take it in order. Paragraph 8, page 56 of the core bundle, describes the positioning of the jacuzzi, positioned above ground level, accessed by 3 steps, central handrail. Steps led to a raised platform at the edge of the jacuzzi. Over the page, paragraph 9, to the right of the platform jacuzzi is a raised decking area. And my lords, what I'm doing now is identifying through the pleadings that there is no dispute about this point. And we alleged at paragraph 9 that that raised decking area was 725 millimetres high. If one looks at the defence, my lords,
Admitted.
Sorry?
That's all admitted.
I'm sorry, Mark, I didn't hear.
I'm so sorry. That's all admitted.
It is admitted, my lord, yes. Because if we look at paragraph 7 on page 71, save that the step was 804 wide and 720 millimetres high, paragraph 9 of the particulars claim is admitted. So the raised decking area referred to, paragraph 8 and 9 of the particulars claim, was admitted. The terminology is something that is consistent. Can I ask you to look at page 60?
Oh, except that you've got to look at 9 as well.
Forgive
The
me.
facts of the decking and the dimensions are agreed. Then you've got to see, I understand what you're saying, that it's preposition on everything is to do with the decking, but you do have 9, the defendant has no knowledge of the facts and matters pleaded.
Yes,
In paragraphs 11, 12, 13, 14.
absolutely, my lord. But what I'm referring to at this point is the parties knew what they were talking about when they
With
talked
the
about
words raised decking.
Yeah.
Yeah.
So if one goes to page 60, which is the particulars of claim, this is within the particulars of negligence and breach of duty, little or letter D. failed to have in place a suitable handrail and guard along the exposed edge of the right raised decking. How does the defendant deal with that? We turn to page 72. And in relation to D, the regulations do not apply. Further, and in any event, the raised decking area was clearly defined and the edge was clearly visible. So there's no doubt about what we're discussing. If one goes to the trial skeletons, so my lords, this is the supplemental bundle. And we were to look at the claimant's trial skeleton. This is divider 3, page 7. I should perhaps take you first to page 6, the bottom line. Having looked at the pleadings, we were able to plead, in terms of the layout of the Appellant jacuzzi, parties agree, and over the page, we have the jacuzzi is positioned above ground level, steps led to a raised platform, at little b, to the right of the platform jacuzzi was a raised decking area. And then little d, the front of the jacuzzi platform and right raised decking area was unguarded and left exposed. And we refer to the heights. If we look at page 6 again, my lords, before what we say are agreed facts or agreed issues, paragraphs 7 and 8 are important. Court is referred to page 663 of the bundle.
Sorry, which page are you on?
Page 6 of the supplemental bundle.
Yes.
Paragraph 7. Second line of paragraph 7, claimant will say that SC was caused to fall from the raised deck area to the right. And we refer there to the photograph, which is page 393 of the trial bundle, but it's the photograph, my lords, I took you to, which is at 198. The claimant's photograph with the X and the arrow. How did the defendants deal with this in their skeleton argument? Divider 4. Page 27 and 28. I've already taken you to the fact that there's an agreed case summary. We have paragraph 5 of the defendant's skeleton. If I give you time to read that paragraph. See paragraph 5, my lords, the defendant clearly is referring to the edge, identifies that they know exactly what the claimant is saying. The last two sentences, various accounts are recorded as to the mechanism of the fall, but my lords, there is no issue taken as to the location. Paragraph 6, the defendant's position is it's improbable that she slipped, and that a slip would have resulted in her falling forwards. Paragraph 7, they distill the arguments. Decking was slippery, slippers were slippery, and no barrier. But most importantly, we then get to paragraphs 9 and 10. Over the page, paragraph 9, 4 lines downwards, the area where Mrs. Clements allegedly slipped and the edge over which she fell did not reasonably require guarding. Now, my lords, I make the submission as positively as I can that the word allegedly clearly only refers to slipping, not the location where she fell. Paragraph 10, the most likely cause of the fall, walking too close to the edge of the platform, tripping, stumbling, otherwise losing her balance for reasons unconnected to the design of the spa bath. Wholly the author of her own misfortune, but if she did somehow slip and fall forward, she must have been careless. and that refers to the section 1.7 potential argument. Whether or not that could have sounded in contributory negligence, I'll address you, Models, because there's no case that I find relying upon section 1.7. And whatever guidance I have been able to find seems to suggest that relates to mothers who may be drug addicts who harm their children through their previous conduct, rather than a contributory negligence case like this. But there's no authority that's reported that relates to 1.7. So, we say there's no doubt between the parties what raised decking area means. But in the
case, chronologically, the case summary comes between the pleadings and the trial skeletons.
Absolutely, my Lord, yes. So the pleadings come before the witness statements, before the expert evidence, and then the case summary.
Yeah.
So the case summary is what is the culmination of the litigants who approach the case, try to agree as much as they possibly can, up to that point, and then after that, it's for the judge. Because clearly there are triable issues for the judge. But the parties have narrowed the issues as far as they possibly can, taking into account all the evidence up to the door of court. And the case summary is usually provided literally days before the trial starts.
But according to the practice direction, that's the purpose of the case summary,
Absolutely.
or one of the purposes.
Indeed, my Lord. Indeed. So our submission is straightforward. There is no doubt what the raised decking area meant. The respondent's skeleton takes us at least by surprise. It's divider 5 of the core bundle. And this is dealt with very succinctly in one page, page 32.
Sorry, can you say that again?
It's page 32,
Thank you.
divider 5 of the core bundle.
Yeah. Yes.
They say it was not an agreed fact that Mrs. Clements fell from the right raised deck.
Sorry, which paragraph?
Paragraph 3. my lord.
Sorry, yes, got it, thank you.
And they, through Mr. Block, are making the point that this is a much wider issue. It appears, though, in fact, the dispute is in relation to the word right being added to the raised deck. And it may well be suggested that the whole jacuzzi is raised. We would submit that that's not what the parties were debating. The last sentence, though, perhaps is troubling. It's absolutely clear when the skeleton is read in full that there are no admissions or agreed facts relating to the fall. My lords, you have the case summary, paragraph 1.4, clearly in your minds, I'm sure, but just to remind you, however, it is agreed that after using and exiting the jacuzzis, Clements fell from the raised decking area.
What certainly was in issue was the precise sequence leading to and the mechanism by which she came to fall.
Yes,
That was
an issue.
always an issue
Yes,
on the pleadings, on the case summary, on the skeleton.
yes, my lord, that was an issue. And we submit that was the mechanism related to contrib. That's our submission. The mechanism about slipping relates to whether or not it's possible to argue contributory negligence.
Depending on the findings, you could have a finding of contrib if, notwithstanding that it should be guarded, the edge was obvious and she failed to take reasonable care and just, as it were, walked off it or stumbled off it, or not stumbled off it, but got too close to it and lost balance and so on.
Absolutely.
Yes. You could, in theory, have a pleading, or you could certainly plead contrib in those circumstances.
My lord,
You
yes.
might not get a finding, but you might well.
My understanding is this, that the defendants must have felt that if she did in fact slip on their own decking with the slippers they have provided, they wouldn't be able to argue successfully contributory negligence. But they could if they were to disprove that she slipped. because then it's like that she stumbled or fell off the edge of her own mistake, potentially. That appeared to be, that was our understanding at the time, that they were raising this issue about, and they fought the issue of whether the boards were slippy or slippery quite hard, and you will see from the expert evidence a lot of time was spent testing the decking surfaces, etc.
And it's okay.
And it is okay. The judge found that it wasn't slippery, and in fact the experts agreed that it wasn't slippery in the end.
You also got the first two sentences of paragraph 5, and I'm looking at the photograph of 239. The claimant erroneously equates raised decking with the raised decking on the right. All of the decking was raised, including at the top of the stairs. And if the alternative is that the mother fell down the stairs, you'd have to interpret decking as meaning fell from the top of the stairs. And
Indeed.
I formed the impression, but not scientifically, that as she was the alternative suggested was that she was walking down the stairs, she slipped on the stairs rather than on the raised decking that constitutes part of the stairs, if you're doing that kind of analysis.
Your Lordship is absolutely right. That is the way the defendant is arguing this. We would submit now.
Well, the decking immediately. There is a surround
238 and 239.
front and back,
I think the best photograph,
which is not at the top of the steps. There's a question about it being there being a 5-degree or very small degree of slope towards the pool, but there it's not raised, is it? It's not. You couldn't really describe that as raised. You could be describing to the right-hand side or the left-hand side. The left-hand side with the 3 candle holders, the right-hand side with the 2 planters and the thing in the middle.
that's precisely our point, my Lord. Absolutely.
But is it factually correct that there was not a raised decking area above the level of the pool between the steps and the pool? I thought that it was essentially the same.
Yes, that's right. There's no further raised decking.
Maybe a couple of degrees in it.
It looks flat.
Yeah. Yes. I took a moment to understand your question, my Lord.
Probably my fault.
Not at all. The only raised decking is right,
Left
on
and
the
right.
left. Thank you. But the whole point of my perhaps laboriously going through the pleadings and the skeleton arguments and the evidence that you have and the point that you will see from the engineering evidence is that no one was any doubt about what was being referred to as the raised decking, whether it's called right raised decking or just raised decking. So we submit to now argue that entire Jacuzzier's raised decking is to try and change the basis upon which the facts were agreed. And the solicitors who reached that agreement on behalf of their parties did so against a background of very clear focus on the right raised decking. There's no doubt that that's what we're talking about. So then we need to perhaps focus on the issues that arose in the case, because we submit that the evidence strongly supports our contention that there's no issue about what was the raised decking.
Sorry, which document?
So,
sorry, this is a
subheading of the issues.
Sorry,
yes.
thank you.
So the defendants raise issues in their defence. So we need to go to the core bundle again, models. Their defence is at divider 12, page 71, paragraph 9. We've seen this already because Roger Lewis took us to this point. So the claimant is put to proof. They deny that the cause of the fall was a slip as opposed to a trip or loss of balance. The particulars of denial are set out at page 72, Miles. Paragraph B is of importance. The drop at the edge of the decking was obvious. The surface did not present a slipping hazard. D is of interest because it refers back to the particulars of Claimant, page 60. It says the regulations do not apply. The guidance, which is the additional document K and D and M, do not apply to the surface of the deck. And further, and in any event, the raised decking area was clearly defined and the edge was clearly visible.
Give me you're on D, aren't you?
On D, yes. And just to remind your lordships, we went back to this before. I took you to this when pointing out that the raised decking was understood to mean one thing only by all parties. And then at E, there's an interesting point. The allegation is at page 60. Failed to have in place suitable handrails on either side of the jacuzzi steps to guard against the risk of slipping or falling from the right raised deck area. This was put, Mullins, because the claimant's case was she couldn't reach the handrail from where she fell. Perhaps a surprising finding, or a surprising thing to say if she's fallen on the steps, but her case was she could not reach the handrail. The defendant's response is also of significant interest. Page 72, E. Relevance of this allegation is not understood as it is not alleged the claimant's mother slipped near the jacuzzi steps. So, if we then go to the claimant's skeleton at trial, in our attempts to understand the issues before the trial judge, we need to go back to the supplementary bundle. This will be divided 3, page 6. Forgive me, Mullins, I've taken you to this already, but it does set out what we say are the issues. And then we attempted to distill the case, my lords, paragraph 18 of our skeleton. And in attempting to do so, we say, failed to identify the need for a guardrail at the exposed right raised decking. Failed to, and that's at the point of design and installation. B, failed to identify the guardrail was required when it was modified, because that was a further opportunity when they added the right-hand section of the steps. That was a further opportunity to consider, does the exposed right edge require guarding? C, failed to carry out a risk assessment that would have identified the need for a guardrail. D, failed to provide suitable footwear. And then we raise an issue, or we highlight an issue of factual causation, page 21. Paragraph 55. Fundamentally, had there been guarding in place along the exposed edge of the right raised deck, the accident would have been avoided. Position is accepted by the experts. The defendant's skeleton for trial is to be found on the next divider. I've already referred to the fact that paragraph 3 they've agreed the case summary, my lords. I've already taken you to paragraphs 5 and 6. They attempted to distill the issues of paragraph 7, my lords. The allegations can be distilled into 3. That the decking was slippery, slippers were slippery when wet, and there was no barrier. Had there been an issue, my lords, that the claimant had fallen on the steps, one would have expected to see that at this point. I've already referred to you to paragraphs 9 and 10, where we submit these amount to significant concessions by the defendant, with the defendant accepting that the edge over which she fell did not reasonably require guarding. My lord, I noticed that you slightly shook your head in response to that.
Yes, well, it only goes to show you shouldn't read anything into what you see in my face. It's just the way it hangs. What I was actually thinking was that conceding that it happened with her falling over the edge comes quite close to being an admission.
Yes.
I mean, in normal language,
It does.
given the significance of whether she fell over the edge.
Absolutely, it does.
That was all that you could possibly have read from what you thought you saw.
Indeed, I'm grateful. We say, looking at this now, forensically, in the light of the argument that there was no agreement about how the claimant fell, we submit that proposition in the defendant's or the respondent's skeleton cannot stand, bearing in mind what's contained in their trial skeleton. And what did the judge consider were the issues? Well, if we go to divider 5, page 37, day 1, at the very beginning, during my opening, the judge indicated an unhappiness about the plethora of guidance, British standards that were being quoted in the skeleton arguments and were in the documents, but he makes it clear what he considers to be the issues at lines 5 and 6 and 7.
Forgive me, I missed the page number.
It's page 37 of the supplemental. Day 1, during my opening. The reference to witness statements will
Lines?
surely be skeleton argument. But line 4, the judge, I read with, I confess, mounting impatience, the reference to the CDM regulations. But of course, they don't apply to this. The issue in this case, I think, as Mr. Block fairly summarises in his witness statements, that must mean skeleton argument, is, was it slippery? Was there a barrier? We go back to the point I was making, that the skeleton argument refers to mechanism of fall, not location.
Although you refer to skeleton arguments, they are skeleton arguments.
Yes,
And this is the judge trying to orientate himself at the beginning of the trial.
indeed.
There needs to be something, or does there need to be something more formal? And if so, isn't that why the case summary is critical? Because if that is the
Indeed.
formal thing,
Indeed.
I'm not sure that a skeleton or a judge expressing a view.
My lord, yes. I take the point. Skeletons are not pleadings. They are not formally signed with a witness statement of truth. They are submissions in written form. So ordinarily they do not bind parties. A case summary which records an agreement is quite a different beast altogether.
Yeah.
A case summary which records an agreement is essentially a contract between the parties that we take this issue from the judge.
But you're showing these documents because on your submissions they reinforce the context or the nature of the case summary, and that there is no departure at this stage.
Indeed. And your Lordship has the point exactly. We have no idea at this stage that there will be a departure. The departure appears subtly. The next part of my submissions I've written for my own note is, how do I and the judge become distracted from the fact that there's an agreed fact? And that's of importance, and it's interesting to see how this evolves during the case. The starting point is that the claimant is cross-examined. Forgive me, claimant's mother is cross-examined.
Why don't we simply refer to her as Dr. Clements?
Dr. Clements, thank you. Dr. Clements is cross-examined about what one of the employees of the defendant said. Corrie Bainbridge there were two witnesses called the defendant, Corrie Bainbridge and Miss Dunbobbin, and of course their expert. So if we go to the trial transcript, divided 5, 52. This is the cross-examination of Dr. Clements. And we see the reference to Corrie Bainbridge towards the bottom of that page, line 24 onwards.
Page
52, Mark. And the question begins, now after you had fallen, a number of hotel staff assisted you. Do you remember that? One of them was Miss Bainbridge. She made the accident report, which is 4 of bundle 2. And a long statement ending with Miss Bainbridge, at the bottom of 52, Miss Bainbridge is going to give evidence, and I understand she's going to say she wrote down what you told her. Now, my lords, you'll know from your reading of this case that Miss Bainbridge, in cross-examination, accepted that no such thing. In fact, Dr. Clements did not explain to her, possibly because she was in such shock, did not explain to Corrie Bainbridge what happened. So she was later cross-examined by me about this point, and you find this at 104.
Well, can we just pause? Because are you going to deal in more detail with Mr. Locke's cross-examination? Because we've read it, and certainly it strikes me that he is clearly and very properly conscious of the fact that he was not advancing a positive case.
Yes.
But he does take her to these two documents with either the implicit or the explicit suggestion that they are an accurate account of what happened. So, speaking entirely for myself, my present position is that Mr. Block was scrupulous in his consciousness that he was not entitled to run a positive case. But it does raise a question, which is where someone puts someone to, the question I think is, what was he entitled to put to prove, the claimant to proof of? And, for example, the question on 53, 21 to 25.
Yes.
The only, on your case, the only legitimate purpose behind that question is as to slipping, not as to location.
That's because that was our thought process, my lord, that there was an agreed fact.
Yeah. Well, I think you need to be very, very careful about telling us about your thought process.
Oh, forgive me, yes, of course, I understand.
For obvious reasons.
Yes, obviously, yes.
But that would be your submission, which is that as things stood,
It wasn't relevant.
it was legitimate questioning as to the mechanism or the precise sequence of events
My lord,
leading
yes.
up to the fall.
Yes. Because the steps were not relevant to the issues in the case. The point your lordship has, you're writing in it, your lordship has referred to relates to the typed document that was put.
Yeah.
Yeah.
Yeah, well, I'm just taking that as an example.
Yeah, absolutely. And your lordships will also have noticed that on 3 occasions when such points were put to Dr. Clements,
She said I'd never said that.
she did, I never said it, yes indeed.
And you were taking us to 104,
So 104,
and then going back, I assumed, to 53.
yes, so 104 was my cross-examination of Corrie Bainbridge, because it had been suggested to Dr. Clements at the top of 53 that I understand she's going to say she wrote down what you told her. But Corrie Bainbridge made the point that in cross-examination, when I put to her paragraph 11 of her statement at line 10, it says, I asked her how she'd fallen. She didn't really tell me what happened. She just kept on repeating she'd fallen and hit a bump. She didn't say how. So how did you get the information to write down how the accident took place? Answer, I think her husband, to be Mr. Siddall, should we say, kept repeating that she'd fallen down the steps. So you think you may have got that from Mr. Siddall? I can't recall. All right, but you didn't get it from Dr. Clements? No. Now, that then raises the point about how Mr. Siddall's evidence was not cross-examined. He makes it clear in his statement he did not see the incident, but when he turned round, his wife said what had happened. Your Lordships wish to see that now?
No.
I can take you to its divider at 10, and you'll find it at page 208. Paragraph 18. It's witness statement. I asked her what had happened, whether she was okay. She told me she had slipped and fallen off the decking. Doesn't refer to the steps, which Corrie Bainbridge has written in the accident report form. But the London judge actually rejected Corrie Bainbridge's evidence entirely as being unreliable. So at this stage, there is no document that actually attributes Dr. Clements saying she's fallen down the steps, which is essentially a reliable point. And Mr. Siddall is not cross-examined about what he said in his statement. And the judge doesn't make a finding that Mr. Siddall's evidence is unreliable. For your Lordship's purposes, we have the denials, the three denials. I never told, or I never said I'd fallen down the steps. That's page 53, line 24.
Sorry, line 20.
24.
But also, this was all on a false premise.
Well, that's what we submit, yes. Because this is to do with challenging the mechanism of fall.
No, I meant a false premise in that it's based on...
Corrie Bainbridge.
Exactly,
Yes.
what she's going to say. She doesn't say it.
Well, it's not quite, because they also then introduced the typed document.
I understand that.
Yeah.
Yeah.
So the typed document, though, and your Lordships are aware of this, is a document that's disclosed, interestingly, disclosed in paper form only. So we did not receive an electronic PDF or Word document that we could go back and check the metadata on. Paper form only. And that document, I can take you to it now if you wish to see it again, does not identify the author, doesn't have a signature, etc.
But isn't yours? I thought what you were going to say is Mrs. Dunbobbin did not witness.
Indeed.
If the information in the typed document came from Corrie Bainbridge, then it's knocked out by Corrie Bainbridge's acceptance that she was not told by Dr. Clements what had happened.
That was our position, my Lord. Yes.
That's the submission.
Exactly our position. And that's how we submitted. When the judge introduced the issue about the steps, I was somewhat obviously taken aback, but that's what I submitted. This can only come from a source which is not reliable, Corrie Bainbridge. Aha.
Hang on. If it came from Miss Bainbridge, the judge finds that her recollection is not reliable. If it came from Mr. Dunbobbin, and I got slightly confused, there was one witness statement which seemed to say she didn't see Dr. Clements before she went to the hospital in Penrith. But then in cross-examination, I thought she started to say, oh yes, I do remember now, I did see her beforehand. And then the judge finds
Yes.
Miss Dunbobbin unreliable, honest, but just unreliable.
Well, Your Lordship's right. Say for one thing, I don't think she ever said that she didn't see Dr. Clements before she went to the hospital, because I think she says that she saw her in the spa in the statement because she's been told about it, but she doesn't remember it.
Oh,
She's
okay.
been told about it by the staff that you
Right.
came down to the spa. But she says in the statement she has no recollection
Of
at
that
all.
at all. And then in cross-examination, she said she did.
Indeed.
She remembered it.
One of the strange features is that Corey Bainbridge doesn't mention the accident report form in her witness statement, and Mrs. Dunbobbin does not mention the typed document in her witness statement.
Indeed.
So,
Indeed. And Miss Dunbobbin wrote on the back of the accident
the-
report
twice.
twice, at different times, obviously. And if one looks at the typed document, that also was produced at different times. There were real forensic issues surrounding the typed document. The most important part, if we take it logically, Corey Bainbridge can't prove that Dr. Clements fell down the steps because she wasn't told that, she accepted that. The typed document is a problem, we submit, for the respondents in this case, because Mr. Bobbin's own evidence was, in cross-examination, she may well, contrary to what she previously said, she may well have written it after August 2017. And in re-examination, she reaffirmed that point. But the biggest difficulty, of course, is Miss Dunbobbin's evidence was not deemed to be reliable because she had no recollection of the day. But then in court, at trial, there were pockets of memory that came back to her. But up until the evidence of Miss Dunbobbin, this typed document had no relevance to the case. It was a document that is disclosed, but we don't know who's produced it until examination in chief. So if I can take you to where that commences, page 67 of Divided 5. So at the bottom of the page, Mr. Block, I would just like my Lord's permission to deal with a document that wasn't dealt with in the witness statement. Now, Mr. Block clearly forgot to forewarn me of this, because my own response is, I don't know what it is. And then Mr. Block refers to page 6, bundle 2. The judge says very well. And the document is introduced. And for the first time, Dr. Clements having given evidence, Mr. Siddall having given evidence, we now hear that this typed document was in fact produced by Mr. Moylan on the day itself. That's the case we suddenly are facing. Now, I do cross-examine about it, and your Lordships will have seen that it's put, and she's challenged about this, because she has no recollection.
Can you give us the reference?
Yes, so if we go through...
Before you leave page 68, I wonder whether this is where I got the thought that Miss Dunbobbin hadn't seen Dr. Clements before she went, because at 9:19 says, I missed Mr. and Mrs. Clements when I came over to the hotel, they'd already left.
Yes.
That's where I got that from. So
Yes.
the statement says that she can't remember, but she was last day she was called. She said Dr. Clements and Mr. Siddall had left by then. Okay, yeah, sorry.
And my Lord, you're right, because that is a further point in the litany of points about the reliability of Miss Dunbobbin's evidence. So at 25, in introducing the document, Mr.
Sorry,
Bobbin, page 68.
Oh, sorry, we still
line,
there.
line
Yes.
25.
Yes.
And have you had an opportunity to read this note today? Not before today, no. So the typed document is presented to Miss Dunbobbin on the day of trial, and then it's introduced by her as being a document which she now remembers she wrote up on the day of the accident. And we are 6 years, 6 and 40 years later. So a lot of the cross-examination dealt with issues which don't trouble your lordships, because it was to do with slippers and guidance, etc. But it starts at page 81, where I start to challenge Mr. Dunbobbin's recollections that relate to the typed document. And I commence at line 19. I'm going to now start asking questions about timing and what you know on the day. So I'm asking about Corrivane Bridge. And I question her at line 30, so you get the information from, you say, the accident book. She doesn't understand that question. Over the page, I make the point at line 6, the accident report form is not signed by Dr. Clements. And even though at line 10 I make the point the person involved in the accident should tick the box and sign below, and that's accepted, doesn't know why that wasn't done. Paragraph 21. Line 21, forgive me. I don't remember being called down to the spa. Sorry, my apologies. So I quote paragraph 50 of her own statement at line 23. I know that a number of members of staff can recall I was called to the spa after Mrs. Clements' alleged accident. When I spoke with her, unfortunately, I have no recollection of that at all. And she says, at that time, no, obviously, but having read my statement, then yes, things prompt you. But, and I make the point, this is actually your statement I'm quoting. And then we go into answer 32. When I was asked about my first recollection of speaking to Mrs. Clements was when it was in the bar after she had been to...
Sorry, which page?
That's 82 still, line 32.
Sorry.
And Lord Justice Lewis made this point that this is in fact what she did say.
Yeah, look
She
at
had
that.
no evidence in court. Do you have a recollection of that? She says yes. But not a recollection of earlier in the day before she goes to hospital. No. You don't remember seeing her lying down in the treatment room? No. You don't remember talking to her? No. So when are you saying you first saw the accident report? That should say form, not put on. I would have said it was that obviously I did honestly can't remember when I did or I didn't. And then...
Which document is the reference? The timed sheets you produced in line 12?
I believe that's a typographical error, my lord. I believe that should say the typed sheet, which is the typed document. Because it refers to page 6 of the second
Yes.
paragraph. It's dated 1st of January. A learned friend, on asking Dr. Clements about this, said it was completed pretty contemporaneously. Well, in fact, Mr. Dunbobbin was to say it was completed on the day itself and in stages.
As I understand it, she's saying she completed it at 2 p.m. or thereabouts.
Started it. You started it then.
Or she started at 2 p.m. or thereabouts. But she's also saying at this stage in her evidence that she hadn't spoken at that stage, or she couldn't recall, well, she's saying she hadn't spoken to Dr. Clements at that stage. So if she started at 2 or thereabouts, the things that she wrote at 2 or thereabouts at this stage of her evidence can't kind of have come from Dr. Clements.
My lord, yes.
Well, the 2 p.m., the reference to 2 p.m., so forgive me if I've been very slow. Type note is at 243, it's supplemented my lord. Starts off saying 1st of January 2017, then new line at 2 p.m, 2 o'clock, call to the garden spa by Corrie Bainbridge. So in reading line 19 on page 83, given
Yes.
I timed it 1st of January at 2 p.m,
Yes.
that's not exactly what the note, well, it's not
Well,
what the note says at all. It just says she was called at 2 p.m.
Yes. Yes. I mean, she says she timed it, but that's a very fair point, my lord. It's what she says is that about 2
Happened
p.m.
at that
or
time.
the garden spa.
Yeah.
The accident report form identifies the time of the accident as 1:50. So that would fit if she's called down. But she has no recollection of being called down. So I press her on the timing because obviously it's important. 9:29, right? So 2 p.m. call to the spa by Corey Bainbridge. So you think it was completed then? Yeah, I completed it at 2 p.m. Around 2 p.m. I was called to the garden spa. And you completed it straight away? If I did that, yes, then yes. And the judge intervenes at that point and says, well, just look at page 6. And page 6 is obviously 243 of the supplemental bundle. Counsel is asking you when you think you completed it. It would have been around, it would have been after 2 p.m. And then I tried to press her about when it would have been completed. Bearing in mind this is the 1st of January, I asked her, was it light or was it dark? To try and to assist on line 20. She says it's 5 or 6 years ago, would have been in the afternoon. And make the points, the accident report form refers to 150. And then I ask the question at 28. You sure that you didn't complete this after August 2017, after Dr. Clements wrote to you? She's adamant, no, no, no. And it says, you found Dr. Clements on a chair. Do you remember that? Having read everything then, yes. I remember speaking to you, having been prompted, you start to think about things. So I remember speaking to Mrs. Clements in the spa reception room. And I understandably say, well, you just a moment ago said you had no recollection of speaking to her in the spa. So it's not surprising the judge found her evidence unconvincing, but it gets worse in one respect. She was having difficulties. From my question at paragraph 10, it appears she's looking around for some support. In paragraph 11, I honestly can't, sorry, give me the question again. And then she says at 14, no, she was on, I'm nearly 100% certain she was in reception with her partner. So her evidence vacillates significantly. She's reminded about her own paragraph 50, where she doesn't remember this at all. And then I'm asking where she, trying to ask her where she completes the document. She starts by saying in her office. But then it appears that she's no longer in the office because she's walked the claimant down the stairs. This is now 56. But your lordships, you see this and you see why her evidence wasn't accepted by the learned judge. And then I ask her to look at the typed document at page 86, line 28.
Line what?
28.
Thank you.
Called Mr. and Mrs. Clements at 3:15. So if your lordships have 243 open, you'll see the final paragraph called at 3:15. But of course, I'm probing at this point to try and work out whether or not this is a reliable assertion that this is her document. I refer to the final bit of the typed document in my questions at 87, puzzle 87, about Mr. McLean. PMC informed me he'd seen the couple leaving the building, going to the car park at, approximately 3:30 p.m. And the reason for this challenge is because we have the note from the Penrith midwifery service, which is timed 3:10. I need to address you particularly on that document, but first I'll take you to it now because it's an important point in the whole scheme of the case. The learned judge, we submit, made an error here because he concluded that the note was prepared after Dr. Clements would have left. But in fact, Dr. Clements' evidence in her witness statement, which was not challenged, was that the Penrith note was given to her to hand to her own maternity services when she went, and you can see from the wording of the document 248, she wasn't challenged about that. If one looks at the Penrith note 248 divided 20.
Forgive me, I'm having a bit of a nightmare here. Where's it gone? Okay, I'm back.
You have that. So 248 divided 20. The Penrith note is important for two reasons. One, it undermines the type document and the timings contained within it. Secondly, it's important because it contains a version of the claimant, Dr. Clements' accident. And finally, perhaps the third reason, the learned judge was in error when he felt that this document would have been, he assumed the document would have been left within the notes of the hospital. In fact, it was a document that was intended to be given to Dr. Clements and was given. So if we look at the document, it's 1510 on the left-hand side, 1st of January. It records a fall approximately 1 hour ago. Well, the accident report form does record the fall at 1:50, so it's an hour and 20 minutes earlier. While on holiday in the area, blood pressure taken, pulse taken, abdomen soft on palpation, slight tenderness over the left side, where landed against jacuzzi step. Now, we would make the submission that that's not the normal language one uses when one's fallen downstairs. And her case has always been she landed on her left side, left abdomen, from the mechanism of her fall. But we know that we've got here, Penrith, it's written in, Shona Anderson, registered midwife, I assume, and the date, and advised to seek medical aid and if feels unwell or has PV loss or reduction in fetal movement. And we know from the claimant's own statement, which was unchallenged, that this was given to her. So we have a timing from someone who would record a timing accurately. The claimant says in her evidence, which was not challenged, that she was at the hospital for approximately 1 hour.
The evidence went into this. I mean, the hotel was in Appleby, they had to drive to Penrith, didn't they? And there was evidence, wasn't there, about the time and the distance that would take?
There was no evidence about it.
Oh, there wasn't, okay, right.
I can inform your lordships how
No,
far it
that's
is,
giving
but I
evidence,
can't give
no.
evidence about it.
But no, if it's
it
150
It's
and
more
it's
than 5 minutes.
Yeah, yes, it's
Oh,
150 and it's Dr. Clements was getting himself together after the fall.
Yes.
They dress, go to the car and drive to the hospital.
Yes.
So, yeah.
And, my lord, we also know from the claimant's, so Dr. Clements' witness statement, that she phones, I forget the name of the, she phones someone first and is advised, well, the nearest place to you is Penrith.
I thought you rang her own doctor first, but maybe not.
Yes, there is a name for the contact, but forgive me, I've forgotten it for a moment. But she makes a phone call, she then leaves. The typed document refers to them leaving as being seen to leave, not by the author, but by PMC, which is Mr. McLean, whoever that is, informed me, seen the couple leave the building, go to the car park at 3:30. Simply cannot be right. That's at page 243. Final line of 243. But this document is a document full of questions. It raises all sorts of questions. The second substantive paragraph says, found Mrs. Clements sat on a chair in reception, sat at the setting table, explained she'd fallen down the steps. The third substantive paragraph says, I met the couple in the corridor and escorted them to the lower staircase. When asked how the accident happened, well, the reference to how the accident happened has already been referred to in the paragraph above. So why has that been done twice? And then that paragraph seems to be out of sync with the next paragraph. When her husband came to inform Corrie that his wife had fallen, Corrie went to the garden. Well, that's out of order with what's gone before. The author says they called Mr. and Mrs. Clements at 3:15. That must be an error. And it says, Mr. Clements informed me that his wife was on the phone trying to contact midwife services, asked if there was anything we could do, and to let us know if they required anything. And then they're seen supposedly leaving at 3:30. So this document
Purports to be written before they go to Penrith.
one would assume so, but we don't know how many authors there are of this document. It does seem odd that the third paragraph refers to when asked how the accident happened, when the second paragraph explains that. So how many authors actually are there? And when was it created?
One explanation of that is that the first paragraph isn't actually saying, well, no, she says, found Miss Clements, found Miss Clements, sat up upset and explained. So no, that does sound as if it's a direct explanation. I thought it might, paragraph 1 might be recording, paragraph 2 I checked myself, but no, it's not. They're both written.
Does it explain, my lord? Yes.
Yes, they're both written as conversations between Dr. Clements and Miss Dunbobbin, I think, aren't they?
But my Lord Justice Stuart-Smith has said that suggests that this is written before they go to Penrith. But that's not necessarily the case. And we know from Miss Dunbobbin that she accepted that this could well have been written after August 2017.
Well, where did you get that acceptance? Because in the passage you sent us to,
well, I'll take
took us to, you hadn't
I'll take you to it now.
cracked that particular point.
So, page 87, I'm taking her to the Penrith note. So, paragraph 12, line 12, forgive me, can I suggest to you that those timings are almost certainly wrong? Right? 3:15, that you phoned the room to speak to Mr. and Mrs. Clements, Dr. Clements, and Mr. Siddall. Do you accept you may be wrong? No, because we know from Penrith, they're in Penrith at 3:10. Okay, I ask you to look at it. Do you see that at line 22? Can you see the time? Yeah. Does that suggest your timings aren't right? So it does suggest your times aren't right, doesn't it? It does, yes. 26. So that does suggest you've written this sometime after the event and you've estimated the time that you called. Do you agree? I don't disagree. But look at the last sentence. P. McLean, that's Paul McLean, isn't it? It is, yeah. Informed me he'd seen the couple leaving, etc. That can't be right either, can it? No, given the hospital time. Right. Now the reason I'm asking you is because I'm trying to work out when this document's filled in and when it's completed, how it's completed. And I refer to the fact that you didn't report it to your brokers because you didn't think you needed to. No. Line 9, and this statement doesn't say that you've created a contemporaneous note just for your records. No. So, is it possible you actually wrote the document we were reading at page 6 when you received the email from Dr. Clements in August 2017? I can't honestly answer. I can't remember. I do remember writing the report. I do write notes out of things that I think I need to be reminded of. Question 18. Is it possible you got the circumstance of the accident from Corrie Bainbridge? No, I honestly believe she was sat in the chair in the spa when I went. That's my recollection of things. But of course, that's a contradiction of what she's said in her statement. I then come back to the point forgive me, just find my note. Yes, so she's, forgive me, that's where she said, I can't honestly remember, and then she's re-examined by Mr. Block. And this, we go to 94. Line 20. All right, and Mr. Williams was suggesting to you that you wrote this document on page 6 after receiving the email on page 7, which is 7.5 months after the incident. Yes, is it possible you waited 7.5 months to create the document at page 6? I honestly can't. Question,
Couldn't
you
possibly
can't
be
say...
described as a leading question, I suppose.
Indeed.
All that was re-examination was for, my lord.
But she says she can't say.
She can't say, and Mr. Block says, you can't say, all right, thank you. No further questions. Not getting the response, despite potentially leading, that he wanted. So we make the submission. Her evidence was very difficult, and the judge accepted that. Her evidence was unreliable. But the only evidence of steps comes from the accident report form, which Corrie Bainbridge says she doesn't get it from the claimant, Dr. Clements. She can't get it from Mr. Siddall, because he's never referred to steps, and that wasn't cross-examined. The typed document is introduced on the day, and it's fair to say that that is a form of ambush. Never mind. It's introduced on the day of trial that actually this was produced by this witness, and I'm going to introduce it in chief. But nevertheless, having challenged it, that evidence falls apart.
Forgive me, you may have taken us to this. Did Mrs. Dunbobbin actually say, I was told by Dr. Clements that she had slipped?
No.
That's what I thought.
No, if one looks through the whole of Angela Dunbobbin's evidence,
So,
it does not refer to the fact that
So-
Dr. Clements said she slipped on the steps.
she didn't witness the accident.
No.
It must have come from someone else. The only person who's been identified as saying slipped is Corrie Bainbridge,
Slipped on the steps.
who
Slipped on the steps, my lord.
slipped on the steps. Is Corrie Bainbridge, who is discounted
Yes.
because she says she wasn't told that by Dr. Siddall,
Yes.
Dr. Clements.
Yes.
But if you've satisfied, I mean, if you discount the oral recollections of the witnesses, I'm just thinking out loud, if you discount the oral recollections of the witnesses, but you are satisfied that a document was created on the 1st of July 2017, so it's contemporaneous, and if you're of the view that none of the witnesses can generally remember after this time that the document was in fact created, is the judge entitled to say, well, this is the only thing that was created on the day that is contemporaneous, and therefore, on the balance of probabilities, it's more likely than not that that is a correct record?
Well, my lord, if it was created on the day, is the big point. Your lordship,
But it would still it would still raise the question, where does that information come from?
indeed, indeed. But when the judge asks me about this, my response is, this is all based on assumption, because Corrie Bainbridge finds her at the bottom of the steps. Therefore, there's an assumption here that's crept in, because there's nothing ever that suggests that Dr. Clements has been inconsistent about this. There may be an issue about whether she put her foot in her slipper and then moved, or whether she took a step. That may be an issue, but falling off the ledge or slipping on the steps has never been something that Dr. Clements has suggested. So where has it come from? The most likely cause is that Corrie Bainbridge, attending the scene, sees her at the bottom of the steps. It might be helpful to look at her statement.
So before we leave that, and in response to what my lord has just said, the contemporaneous note, if you accept it's on that date, and if you say I
Yes.
don't accept any of the other evidence, they're trying their best, but they can't remember. And if that note was written down, and that note says, I spoke in the corridor to X, and X said to me, is that not evidence that the judge could accept?
Well, potentially it could be accepted.
You'd have to call X.
Pardon?
You'd have to call X.
Because it does say,
Yeah. You'd have to call X, yes. And it's not Dunbobbin that said that, Mrs. Dunbobbin. And her evidence has...
her evidence is gone.
gone.
The judge has announced that Dr. Clements is not reliable, so he's trying to find out something that is reliable, and if it was created on the day, he thinks that's the most reliable document to record the conversation that happened.
And that's when we get to the unfortunate episode of the metadata.
Yeah.
Because that is introduced after the evidence is closed. And my own friend approaches me at lunch break to say, I've received an email, I'm going to ask for the judge to admit it. So there's an argument about it. The metadata is admitted because some judges have a practice of saying, well, it's a question of weight. Everything is admissible. It's a question of weight. So it's admitted. But the metadata is a problem because it's actually a photograph of a computer screen. It doesn't have the author. It simply says user. And it's produced by somebody who could have been a witness to events, Mr. Mike Dunbobbin. Let's look at the metadata.
Lords, this may not assist
You
very
don't have
much,
copies.
but I've got larger copies made, but the definition goes, so I also had some more colour copies made, which I think are slightly better than the
Okay.
bundle.
I think it might help who had the bigger ones.
Yeah.
So I'm going to hand up 3 of each and give my learned friend Vicky.
Well, I will still have to take you to the supplementary bundle which contains the metadata because the covering email
Yes.
is not included. And the covering email is of significant importance.
Thank you very much.
Thank you. So, can I take you to page 251
Yes.
of the bundle? This is produced at 12. It's an email from Mr. Mike Dunbobbin, who is the co-owner of the defendant premises. He could have given evidence. He didn't give evidence. His evidence would have been important in relation to the contractor at the very least. He has accessed this document by taking a photograph of his screen, and his email at 251 says, not sure it's going to change anything, but we've got back to the office and found Angela's typed account of what happened. Now, this is not introduced as hearsay evidence with a witness statement or an application. Simply handed up. Mr. Dunbobbin did not give evidence at trial. As you can see, the document was created on the 1st of January 2017 at 14:54 and finished at 15:38, which raises other questions about timing. How could it be completed at 15:38?
You're making 2 point. One, if she was at the hospital at 3:10, there isn't time for it to be finished. They won't be back and finished at 3:38.
Indeed.
But if you take the bottom line of the typed, if it was correct that P.
P. McLean, yes.
had seen them go to the car park at 3:30,
That would suggest they're leaving at 3:30.
then possibly this note could have been typed up or completed in 8 minutes thereafter.
Well, you'll remember that Dr. Clements, Mr. Bowman referred in her evidence also to speaking to the claimant in the bar
Yes.
and speaking to the claimant in the corridor.
Yes.
The second and third paragraph of the 243 typed document. Mr. McLean says going to the car park at 3:30, not returning at 3:30.
And also calling them at 3:15.
And calling them at
So
3:30.
if it was completed between 14:54 and 15:38, it's not easy to understand how you would call them at 3:15.
Absolutely,
Because
Mark.
that would be contemporaneous with them being at the hospital when you were typing this. So you wouldn't think you had much time to forget that.
And
Get it wrong.
the evidence was that they were called when they were in their room, although I don't believe that says...
No, that was the oral evidence.
Yeah, that's
Yeah.
You didn't object to the admission of the metadata as such. You said it should be given no weight. Isn't that right?
I did object to it. I said if it's admitted, it's a question of weight. Well, let me put it more accurately. Forgive me. I think I said because everything would be admitted, it is admissible under the Civil Evidence Acts, but it has no weight. But I did object to it.
It's page 161.
Yeah.
You say difficult.
obviously familiarity with the judge's practice is
Yeah.
is an
You
issue.
see, I don't want to keep it from the court because the court might take a view looking at, might be better informed and so on.
Yeah, but I do.
When I read this, I didn't have the impression that your starting point was this should be excluded.
Yes, and your lordship is right, because that's the fairer approach. However, I do raise several issues about the problems with it
You do.
when I make my submissions later.
Can I just check one thing? How do we know that the document 243 is the document to which this refers? I understand the heading says something, but is it just the email from Mr. Dunbobbin?
Your lordship has the point exactly.
Oh, sorry.
Yeah,
What
that's
have I got?
That's the point we make. We
Oh,
don't
right.
know. If one looks at the larger document you've been handed, you can see author on the right-hand side. The author is user.
But before we get to who wrote it, what was it? What was wrote, as Ernie Wise would say? I mean, it just says NYD Mrs. Clements Spa, and that may be a document about New Year's Day and Mrs. Clements Spa. But how do I know it's 243, or do I not know from anything in this page?
Well,
So it is the statement from or the email from Mr. Dunbobbin, when he says, I found Andrew's typed account, so we're assuming that that's a reference to 243.
Yes.
And it's his email saying he found Angela's typed account, which he assumes is 243, and then he says, this is metadata that fits that document. So that's how I get to it. There's nothing in the document,
There's
the
nothing-
metadata.
No, there's nothing in this document to identify it. It's the email that covers it and the instructions to Moylan and Friend. Well, I've checked and this is it. Well, the difficulty, of course, is that Mr. Dunbobbin doesn't provide a witness statement, the statement of truth saying this. He has a financial interest in the proceedings because he's a co-owner. And why take a photograph of his screen when they could just email the document? Because if it was a
with the
Word
metadata
document,
attached,
indeed,
which would say more than's on the screen,
absolutely, my lord.
or might.
Well, it might do, and that's why I made the point that disclosure was carried out as a paper exercise in this case. We never received Word documents or PDF documents that we could interrogate on screen. So why send a photograph? And then, can I take you to 249? Because I raised this point with the learned judge. We asked, this is an email, the lower email, 15th December 2021, is the first one from my instructing solicitor who sits in court. Dear Hannah, the matter has been allocated and asking essentially for documents. Please forward, large paragraph, please forward all documents at the earliest opportunity or in the alternative confirm your content for us to approach the company directly, etc. And the answer at the above, dear Glenn, in response, hope you're well. I've asked the question of my insured in relation to the queries below and the brochures in question. The insured have confirmed they do not have any further information other than what has already been provided, as they change computer and email and no longer have access to earlier information.
The request from Owen Mitchell is not specific does not specifically cover a document, this document.
No, it's a general document.
So what you're really concentrating on is the response,
The response, yes.
which is saying we've changed our computer system and we haven't got anything we can do.
Absolutely not. And I raised,
And if,
forgive me,
yes, and if, as often happens, the electronic document had been provided, I mean, the difficulty is you don't necessarily know until push comes to shove in the course of a trial that the metadata may be relevant. But at that point, if the metadata becomes relevant, then it should be disclosed in proper form so that people can interrogate it fully.
yes.
Leave aside your points that there's no witness statements and nothing else
Indeed.
to support
Indeed.
it. I'm really troubled by this because Judge Sephton is a very experienced, fair-minded judge. This court knows from
Yes.
previous experience,
Of course.
and he gave it limited, but he did give it some weight.
Well, he gave
Is
us-
it, and is it your submission now that he should not have admitted it at all, or that he should have admitted it and given it no weight?
Well, I couldn't argue he shouldn't have admitted it because I effectively conceded that point. But I
No weight.
made the point that there should be no weight attached to it. It's after the close of the evidence. And all the arguments I've put before, produced by somebody who has a financial interest, no witness statement, and it's not the true metadata. It's a photograph of a computer screen. It's not even complete. Not even a complete photograph of the screen. It doesn't prove anything. It could have been created at a different time about something else. I'm not suggesting it's been created for the purpose of trying to support the type document.
Well, you're not really in a position to make any submissions about it,
No.
because what we've got is a photograph of a screen.
Absolutely not.
I mean, you just, from this document, you can't connect it to the typed document. You've got to have the email as well, and you've got to assume that that's what he's referring to. And is the position then, you ended up, if you're right on that, none of the witnesses' oral testimony is regarded as reliable. The judge won't say they were dishonest, they just couldn't remember accurately. The only thing you're relying on is the typed account, and the evidence already at the trial was, I don't know when that was made, and
Yes.
it's got internal inconsistencies.
Yes.
So you're then back with the situation that there's nothing to prove or disprove anything, and the only thing you've got is the case summary.
And then, my lord, the overarching point is there was an agreed fact. Of
Well,
where she-
exactly. The only thing that you've got in the turbulent seas is the rock of the case summary.
Indeed, my lord, indeed. Now, the learned judge, as you've very fairly pointed out, my lord, is a very experienced judge, a very fair judge, but he has been persuaded that this has some evidential weight. We submit it does not. And he has used the metadata document, we call it metadata, it's not actually metadata. He's used that to support his conclusion that there is some truth to the assertion made on the day of trial only that the type document was created on the 1st of January 2017. Why did my learned friend's clients consider it was necessary to go and get this document? Because they were obviously concerned that the assertion that the type document was created on the 1st of January 2017 had been frankly debunked. That assertion had failed because of Miss Dunbobbin's own acceptance. She may well have produced it after August.
Well, between the two of you, you managed to get it possibly to August.
Yeah,
Or post
between the two of us, yeah, indeed.
I just read paragraph 14 of the judgment again, and he does seem to accept that he was accepting Miss Dunbobbin's recollection of events as to the fine had been done on the 1st, and he doesn't seem to have been relying solely on the metadata.
His critical finding is, I'm convinced Miss Dunbobbin, beg her pardon, would not say or record anything she knew to be inaccurate or untrue.
Notwithstanding any reservations about her accuracy
And
as an
that-
historian,
Yeah,
I
and
do
that-
accept
and that
her
takes,
evidence.
takes him into the type document.
Yes. We don't suggest that she said anything untrue. We suggest that her evidence was unreliable. And when she said it could well have been created after August of 2017, we say, yes, you're probably right. So we go back full circle to the agreed fact. And it may be now understandable why or how it's happened that we've got to a situation where this has been raised. But if your lordships remember my learned friend's submissions to Judge Sephton, a very small part of those submissions, only about 5 or 6 lines, related to this might be the steps, it might be the ledge. Very small. It was almost an afterthought within his submissions.
Well, can I be sure that we've
Do you wish to look at that?
correctly identified?
So this would be the end of day 2.
I've annotated most of 164, and 165 lines 14, 16.
Yeah.
And he, in one sense, he doesn't put a case. He says if it was the ledge, but then he makes his submissions about slipping. And at 25, 166 line 25, there's an issue.
And then it's the real point at which he refers to, it could be the steps or the deck, is 166, 25, line 25. To line 31.
Yep.
That's essentially it, within the whole of the submission. And we make...
But he can properly say that he was not advancing a positive case, that it was somewhere other than the ledge. Because his submissions are consistent with simply attacking slipping.
Yes.
Do you accept that?
I do accept that. The judge is in error, though, because he's taken that to be...
Yeah, well, where we go from there is a different matter.
Absolutely. But the defendant's position is we are attacking the mechanism. And that's why I referred you to the mechanism. And there's no reference to we are attacking the location.
I think you should have referred to 163, where I start my at line 29.
Mr. Rogers mentioned to me that he refers, yes, he does refer between 163 and 29. And then it's or she fell on the steps at line 33.
But he's being very careful, and I don't mean that in an insulting way, but he is being very careful not to advance a positive case about where it happened. He's allowing it to be an issue for the judge. But
well, indeed, but whether or not that should...
whether that's permissible is a different matter.
Indeed, indeed.
But you are content with the suggestion that I made earlier, which is that his submissions are consistent with not advancing a positive case about the edge.
Absolutely, when it's looked in the context of mechanism of fall, rather than location. Yes.
But he leaves the issue open of steps or ledge,
And
as he's just brought to us.
that's where we do complain,
No, that's where you complain.
because that's not appropriate because of the agreed fact.
But you didn't complain at the time.
I didn't, my lord, no. I didn't. And obviously I've asked myself many times, why not? Why didn't the judge complain either? Because the judge and I, and all of us, knew what the agreed fact was. And when I responded to the judge's questions, I referred to the point about Corrie Bainbridge being the source of the issue of the steps.
Does it matter whether you objected or not?
Well,
because if it wasn't an agreed fact, we're all human.
Well, indeed.
If it wasn't an agreed fact, it wasn't an agreed fact.
Well, that's...
If you're right.
Essentially, yes. It's unfortunate that I didn't step in immediately and say, hold on a second, that can't be raised, we have an agreed fact. But that in the heat of battle, when I'm asked a question by the judge, which surprises me, about his concern about the steps, I respond by saying, well, the evidence that relates to steps is wholly unreliable. Yes, of course, I should have said, you don't need to worry about the steps, it's not relevant. But as your lordship says, the reality is the judge is not seized of the question.
If he's not seized to it, he's not seized to it, yeah.
And that's the fundamental point. And looking at it, perhaps, I hope not with too much hindsight to make it favourable to the fact that it was not raised with the judge immediately. But that stresses the importance of agreed facts. Because in the heat of battle, individuals will not always respond quickly to a judge's interjection with exactly the right point. Now, if a fact is agreed, it's incumbent upon all parties, not just the one who wishes to rely upon it, because it's a good admission. It's incumbent on all parties to make sure the judge doesn't stray beyond it. Not just for the one, or in our situation, ourselves. So we make the submission that yes, of course, we should have raised it, but that doesn't detract from the fact that it was there. And I took you in your submissions earlier, my lords, to the beginning of the judge's interjections in my opening, where he identified the facts. Is it slippery, or is there a need for a barrier? Because in fact, those were the issues in the case, and it developed over the 2 days to, well, it could be the steps, or it could be the ledge. So what should a party do in that situation? Well, a party who wishes to say, we don't want to rely upon an agreed fact anymore, should say so. As a party who doesn't want to rely upon an admission, should say so. And there needs to be an informed debate, because if a party is attempting to reopen an issue and put the factual issue back before the judge, that needs to be done very clearly, and the judge needs to accept that it's appropriate for the judge to take on the factual issue. And that's where, unfortunately, we have to submit the judge fell into error. My lords, you now have, or should have, available some hard copies of the engineering evidence, and there are some pages that I'd like to refer to from it, but only about 6. We've got the copies.
You got the copies? Yes. They haven't come on to us, or just.
If we can just hand them out.
I've got a hard copy which I've marked up, so could you use internal numbering when you can?
When I can, my lord, yes.
Thank you very much.
Mr. Williams, can I just raise one thing before we start, which may help to clear the decks on,
Yes.
on the experts? Both experienced experts and indeed Mr. Cottrell recognise expressly that what happened is a question of fact for the court.
Yes.
So one can see where they were directed and
Yes.
what they looked at, but they did not make the mistake of doing anything which demonstrates of itself that this was an agreed fact. So they don't. Neither of them say it's agreed that blah 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 or not.
No, the timing is important because, of course, their joint statement
Yep.
is dated, I believe, 2021. So it's just a moment before I double check. 16th of September 22, forgive me. Their joint statement is 16th of September 22, which predates the agreed fact by some months.
What, in the case summary?
Yes. So, of course, they are working on the basis of the pleadings and the statements that they have. And my lord is quite right that we should take care when looking at this evidence. But the only relevance that we could reasonably identify is that they are discussing the raised decking, and they know exactly what they're looking at. So perhaps the simplest place to look is the joint statement. And if you have item 121 and 122 of the joint statement. Unfortunately, I'm sorry that they're not internally
Sorry, item.
numbered. Item 121.
Is that serial 1, 2?
Yeah, serial 121. It may be of assistance to look at the agenda as well. Does your lordships have the agenda?
No, I think what might have happened is I've got serial 121, then goes to 123.
No, but that's where they disagree.
Oh,
They
it's
get
at the
a subsequent
beginning.
page, so it's at the beginning.
Okay, thank you. Sorry.
Sorry, I'm not about mine electronically, so I think.
No, sorry.
format.
So we're going to bullet. We're going to the very summary at the beginning. Is that right?
We're going to, in fact, the reference to the index accident and serial number 121. On the left-hand side column, there are numbers.
My lord, the joint statement is in an unusual form.
Yeah.
And the first part is a table of which is meant
Yes.
to be agreed.
And are we going to the table
Yes.
or the? We're going to the table.
The second part is areas of disagreement, which
Yes.
are called serials.
Right. I
So-
see. So there are only some serials.
Yes.
I got it. Thank you. 121.
121, my lord, yes.
Yes.
So they're dealing there with the index accident, as they are encouraged to do in the agenda that was agreed for them. I don't know if you have the agenda, but it should precede the joint statement. But the agenda had as the index accident the locus from which the claimant's mother fell, the height of the surface from which the claimant's mother fell. And I believe there's no agenda being copied for your lordship, so let me just take you to the joint statements. That's all you
Yes.
need to see. 121. It is understood that Mrs. Clements fell from the raised deck area to the right of the
Yes.
spa pool. And of course, they don't overstep their ambit. If the above is accepted, she
Yes.
fell a distance of 720 or 725.
Yes.
If we need to, my lords, within Mr. Cottrell's evidence, unfortunately, it's not. I don't have page numbers, but it's paragraph 1.6.
Sorry, could you say that again?
Mr. Cottrell 1.6.
1.6. Yes.
He refers at 1.6 to the edge of the raised deck at the end of that paragraph.
Sorry to be slow catching up. I've only got Sandal and Lemon.
Yes, Mr. Cottrell's evidence is an annex to Mr.
Oh.
Andal's evidence.
Right.
Sorry.
The reason, my lord, is that Mr. Cottrell, through illness, couldn't continue with the case.
Right.
Sorry. In the wrong place. Where is it? It's an annex to Mr.
It's an annex to Mr. Sandal. And
I've got appendices. And there's an annex as well. Oh, here we are. Yes, right at the very end.
yes, and it's not foreign to it. It's
And that's
all
page
right.
numbered.
Not internally, my lord. It's paragraph 1.6.
Wait a minute, I haven't got there yet.
My copy has got internal pages for Mr.
Yes.
Sandell's report, which run up to 53. If one goes on from there,
Is it dated the 18th July 2019?
Yes.
Yes, I
And
got
it's
it.
Finch Consulting.
Yes.
Right. So it's after page 142.
21st of September 2018. That does
Oh,
basically
okay.
the site inspection.
And I've got the wrong. No, sorry. No, I haven't got the right one.
Well, I can.
What's a
I'm not troubled if you don't have that, because
It must be in here somewhere.
That's the claimant's expert. Perhaps it's more helpful
Any
to look at the
indicator.
defendant's expert.
Anyway, you wanted to take. I'm not going to give up quite yet. Whereabouts do you think it is? It's an annex to
The 18th of July report,
18th July.
Mr. Cottrell, and it should be an annex to Mr. Sandell's.
And does it begin, Dear Glenn, one introduction, I prepared a report for the court reference.
I'm looking.
Looks like that.
if you go through Sandell,
Yes,
my copy has certainly got bottom page numbers.
yes, I do.
You go up to 49, up to 53, and then you go on one, to the next page, after page 50, and generally number 53.
Okay.
Got it?
Yes.
But there isn't a 1.6.
'If you go on,
is 2 pages further, 4 pages further.
yes, there is. If you go, no, you're on the wrong document. It's go to page 53. 53.
Yeah.
And it's the next one.
Oh, right, it is. Right, I've got it now. I'm so sorry.
I'm sorry, Ronald, to cause you some difficulty. But obviously we weren't expected to produce these documents to you. But 1.6,
Yes.
he refers to the edge of the raised deck.
Yes.
And this is just simply to reinforce the point that everyone knows what they're talking about. And
Yes.
so if we were to go, for example, to Dr. Lemon's evidence, Dr. Lemon is, of course, the defendant's expert,
Yes.
and we were to look at internal page 25 of 56.
Yes.
We will see there, paragraph 3.2.10, 6 lines down, the raised deck area was positioned 720 millimetres above the ground floor.
Yes.
The ground below it. So Dr. Lemon's not confused about what the raised deck area is. Again, internal page 38, he reports 4.6.5. It is
Yes.
evident from the above that the fitting of guarding around the edge of the raised deck area would have been consistent with the recommendation of PS 6180, given the change of level. So we make the point that there's no question of anyone being confused about what the raised deck area is. At 5.5.1, internal page 47, he makes the point, 5.5.1, if the claimant's account of her fall is accepted ultimately by a court, then it is apparent that the fall
Wait a
was
minute.
not
5.1.1.
5.5.1.
Oh, 5.5.1, sorry.
Internal page 47.
Yes.
The claimant's account of the fall is accepted ultimately by a court, then it is apparent that the fall was not initiated on the steps, but rather on the raised decking. And then finally, we have the photograph prepared. So this is in the supplemental, or the appendices C of Dr. Lemon. And it's very similar to the photograph you have at 198 of your supplemental bundle. But Dr. Lemon has put a circular ring made of dots around the location where the claimant's mother says she fell. This is not internally numbered, I apologize for that. It's Appendix C of
Yes.
Dr. Lemon.
Yes.
And you want photograph 2?
And it's photograph C2.
Yes.
So this all goes to the submission, Ronalds, that the parties before trial, when writing the case summary, were in no doubt about what the raised deck referred to and what the agreement referred to. And also, in relation to a question Lord Justice Stuart-Smith asked of me about admissions and resigning from the same, your Lordships will find this at the CPR 14 specific section that relates to admissions.
Go on. CPR 14?
CPR 14.
14 what?
14.1.
Yep.
Page 450 of the current White Book.
No, we don't have that. 2022.
It's 14.1. CPR 14.1.
Yes. So which?
So, was the
Yes. Sorry, which paragraph are you saying?
14.1, a party
Yes.
may admit the truth of the whole or any part of another
Yes.
party's case. The party may do this by giving notice in writing. 14.15, the permission of the court is required to amend or withdraw an admission. The procedure is set out in the practice direction. You'll find this at 468 of the version of the white book I have. Practice direction dealing with admissions,
Yes.
14 PD1, admissions generally,
Withdrawing.
with the court's permission, 7.1.
Yes.
The grounds have to be
Yes.
set out. So your lordships wish to have some guidance about the process for admissions. There isn't a similar process for resigning from agreed facts, but my lord, if it's deemed to be an admission, this would have been the process.
If you look back at the 14.18,
Yes.
the authorities referred to, I would describe, I mean, they start in 1892. I would describe a lot of them as quite old. Do they, my Lord Justice Stuart-Smith referred previously to the rule dealing with case summary. Can you remind me where that is?
Practice direction 29.
899. Yes, so if I just take you to this, it's my page 899, but if you have an older edition, it's going to be practice direction to CPR 29.
What the point I was getting to rather slowly is that a lot of these cases look as though they predate, in particular, the Wolf reforms. Can't now remember when they were.
98.
They were certainly after 1892.
Yes.
I'm comfortable with that in 1896.
Yes.
But other than that, so I mean, so that I'm just sort of wondering whether the authorities have caught up with the change.
There are significant cases since Hollis and Burton, which
There
is
must
the
be.
1892 case, and this is an issue on area which is quite prolific, in fact, in this type of litigation,
Right.
where admissions are made
And then somebody wants to
filed.
withdraw from
Indeed,
bizarre.
it does
Yeah.
happen frequently. So the cases that are referred to at 1419
Okay, more modern.
are more modern.
Okay, thank you. I see.
But it is a very frequent issue.
Okay.
Thankfully dealt with usually by juniors. The early skirmishes of litigation. Admissions are made more frequently in low-value cases, of course.
Yes, and encouraged.
Yeah, encouraged. Now, looking at case summaries, this would be practice direction to CPR 29. Grateful to Miss Murray for assisting me on this. We have 5.7 brackets 1, which is under 29 PD 5.7. Your lordships have that page.
Yes, yes.
And it starts, a case summary should be designed to assist the court to understand and deal with the questions before it. B, she set out a brief chronology of the claim, issues of fact which are agreed or in dispute, and the evidence needed to decide them. C, should not normally exceed 500 words in length. D, should be prepared by the claimant and agreed with the other parties if possible. That's the question direction.
In terms of the status, I was wondering how it was that, in inverted commas, an obligation to prepare a case summary arose, but it seems there isn't an obligation, it's just 5.6. It's the duty of the party and their legal advisors to consider whether a case summary would be useful. Or
Yes.
was one ordered here?
I believe it's standard now to order a case summary. Standard directions are for case summaries to be prepared. So I would be very surprised
agreed
if
if
it's not
possible.
ordered.
And agreed if possible.
And agreed if possible, indeed. Yeah. Same with trial bundles.
Yes.
But
And
it's become part of the standard direction.
And it's all consistent with the overriding objective to narrow issues and
Absolutely. Yes.
etc.
Indeed.
It might be quite useful to know if there was an order saying there shall be a case summary, rather than a case summary would be useful. It probably wouldn't
Well,
matter.
let me have a quick look to see if I can find that in the
I'm
old
sorry to
bundle.
be so difficult,
At all, no.
just to
If you
bottom
could just
everything
bear with me
out.
for a second. So directions to trial were given on the 10th of May by District Judge Davis, sitting in the Civil Justice Centre in Manchester. And pre-trial directions were as follows: pre-trial checklists, and he ordered no, he didn't order a case summary. I can't see that.
But did he refer to standard directions? Because you may find that there's a separate set of standard directions. Anyway, the solicitors between them can
Yes, I'm sure. But I'm just looking at the order now, my lord. I can't
ease the
see
passing.
the specific order for it. They do follow the standard directions procedure. Trial directions as follow: estimated length of hearing. By 4 p.m. the parties must file with the court a single composite sheet of availability. That's not relevant.
Okay, don't worry. Thank you.
If someone finds that there was an order, could we just be provided with it as
Certainly.
electronic?
Certainly.
Yes.
Indeed. So, my lords, those are essentially my submissions in my appeal, in our appeal. If there's anything that I haven't made clear, could I ask you to identify that? Or if you wish me to expand on any particular point.
If you don't succeed on ground one, so we find that it was, at least in theory, a finding that was open to the judge. Then you essentially make about 3. You say your client's account was consistent, Mr.
Yes.
Siddall was not cross-examined, and the typed document has the flaws to which you've referred, and we can ignore the
And the metadata.
accident report form because Corrie Bainbridge.
And the metadata, yes.
And the metadata should be given no weight at all.
Indeed. There would be a little bit more that I would argue, because...
But I think it's in your skeleton. I was just trying to make sure that I got
Indeed.
the
But-
essentials.
What I would add is that the judge's actual criticisms of the claimant's evidence bear some scrutiny.
Well, that's really difficult, if I may say so, because I've read her evidence and have the cross-examination of her. And to speak entirely frankly, there's nothing in that which leaps off the page as being clearly worrying in the sense that the judge found. But
Indeed.
he's the trial judge, and he formed an assessment of her as a
I
witness.
fully accept that. Fully accept that.
And can we really, if the issue was open to him, can we go behind his assessment?
Well, my lord, you can if you consider that his finding was not rational,
Plainly wrong.
plainly wrong. Now, there is one point specifically I need to refer to, because the learned judge relied on one point, which he said was an evasive answer, and he made a mistake, an evasive answer,
Yeah.
and he made a mistake about that.
Yeah.
But I do fully accept that a trial judge has heard the witnesses, and it's very difficult for this court to overcome that.
But on the evasive answer, you simply say, look at the bottom of the email where Mrs. Dunbobbin says we're going to carry out an investigation. There's the explanation.
Well, that's part of it, but it's actually not that.
Okay.
I can take you to judgment, which you'll find at 6 of the core bundle.
Sorry, can you say it again?
6.
Six.
2 divided 6, yes.
Yes.
Page 42
Yes.
is the area where the judge explicitly deals with the claimant's evidence. Now, there are essentially 4 points here. I'll make them very briefly because I understand that this is difficult for an appellant. But the judge, starting just on the page before, did not accept the suggestion that the emails were not pre-litigation emails.
I'm very sorry, could you just give me the paragraph you're
So
in?
it's the very top of the page of 42.
Yeah.
He says, that, starting at 41, he says, I heard Dr. Clements' evidence. She's asked about her email of December 2017. I should be asking you to look at 41, paragraph 18. And he refers to an email of December 2017. That's an error, it's August 2017. It's in the context of her evidence, and she says that she is writing to get a point across, not a pre-litigation email. And her evidence in court was she was approaching this as a GP would, like a Coward's investigation. And we would submit the judge unfairly criticised her for that approach. She's not a lawyer, she's a GP. That's one point. Number 2, he says the difference between the emails and the version of events in her evidence were materially different. And we accept that there is a difference between putting a foot in a slipper and it moving forward and putting your slippers on and taking a step. But we say he's gone too far by saying that the fact she put forward a different account from the one she currently insists is accurate reflects either upon her honesty or her credibility. We submit that that's unfair. Because as Mr. Block said, this happened in a split second, and it's understandable that an individual will reflect back on what's happened. If she had said, at one point I fell off the ledge, and then another point she said, I slipped on the steps, that would be a material difference. This is a very subtle difference. We say that that's unfair to say it affects her credibility and her honesty. We say it might affect her reliability, but it goes too far. Third point, I found that when asked difficult questions, Dr. Clements gave responses not coherent, to the extent at one stage I had to intervene and ask her what she meant. We submit that as well is an unfair criticism. At one point, she is struggling with an answer, and she's asking for a glass of water. And the second point is the one about the pals.
Can you take us
Yes.
through what you think he's referring to there?
Yes, so if you look at the cross-examination, A1, so there are 2 interjections by Judge Sephton. First is at 58. So Mr. Block at line 5 on 58 is asking, at line 5, and you had a lot of time to think about what must have happened in a split second. And she gives a response. I think the thought is, and it's that response is not clear. Judge says, well, I'm trying to take a note of what you're saying. And then she says, do you mind if I just have a glass of water, sorry? So he allows her a glass of water. And then she goes on to respond. The second occasion that he intervenes is at page 60. And this is to do with the emails and her evidence that she didn't consider that they were letters before action, so did not need to be legally accurate.
What line are you on?
So this starts at line 15. And Mr. Block is putting, but you told my lord that you didn't realise you had to be legally accurate in this document because it was only being provided to give the gist of what had happened for a health and safety investigation. But that's not right, is it? And she says, it is right, I think there are emails. And the judge says, the point in this is the second intervention, and he's referred to his interventions. point in the question is whether you were told it was an investigation, or whether you were told it was a health and safety investigation. Do you understand? The answer, there might have been an investigation. And then she goes on to explain to the judge, from 28 onwards on that page, over the page, at 9, she says, well, I assume that they were investigating. I don't know, I just thought that at this time, I wanted to see the outcome. So, for instance, if as a doctor, you make a mistake, people write to PALS, and they investigate to see if any mistake was made. The patient then gets the report, and there onwards, they decide what to do with that. So, we submit that there are 2 interventions, and neither of those could suggest that she's being evasive. And then I have a 4th point, perhaps the most important one of all. I'm going to take you back to the judgment. Page 42 of the report. At the top of the page, halfway through this paragraph where there are the 4 criticisms, it's put, when it was put to her that Mr. Dunbobbin had asked her about the accident. Do your lordships have that?
Yes.
Yeah.
Dr. Clements did not deny the suggestion. She explained that the slippers she was wearing had caused her to slip, but she did not directly address the record containing the file note, which continues after the reference to slippers, that Dr. Clements put them on, walked down the steps and slipped, landed on the bottom steps. Having regard to these matters, now, in fact, if one looks at 553 over to 554, she did, in fact.
You only say 553. I don't have a 5.
Tab 5.
Sorry,
Oh,
tab
tab 5.
Beg your
Oh,
pardon,
right.
tab 5. Forgive me. So this
Sorry,
starts
so
at the bottom.
what he was saying that didn't deny the suggestion. Okay.
Yeah, didn't deny that she had slipped down the steps.
Yes.
And the question starts at line 34 and 53, and she then, after you'd had an opportunity, I don't want to use the word recover to me, etc. The question goes on, and her recollection is, and she recorded this, that she asked how the accident had happened, and you said you'd worn wet bedroom slippers and had come out of the jacuzzi, put them on, walked down the steps and slipped. So that's what's put. The judge has not recorded.
I'm very, very sorry. Where exactly are you?
I'm looking, I beg your pardon, it's line...
Page 53.
Now
54.
I've moved on to 54.
Line.
So line 4,
Yep.
question is, and her recollection, meaning Mr. Bobbin, and she recorded this, referring to the typed document, that she asked how the accident had happened, and you said you'd worn wet bedroom slippers and had come out of the jacuzzi, put them on, walked down the steps and slipped, landing at the bottom of the steps. That, my lords, is what the learned judge is referring to at page 42 on the 7th line, when it's put to her that Mr. Dunbobbin had asked about the accident. And if we look at the full answer, you'll see at the very end of the answer she says, but I did not say to anybody that I fell down the steps, because I didn't fall down the steps. The learned judge was wrong to say that she did not respond to that. He said, when it was put to her that Mr. Dunbobbin had asked about the accident, she did not deny the suggestion. My lord, she did. And immediately after that finding, which was an error, the judge then says, having regard to these matters, and in particular having regard to her demeanour and witness box, and to the conclusion, I must treat Dr. Clements' evidence with great caution. Well, the last point, my lords, unfortunately, is an unfair one, because the judge missed the answer. So I fully accept, my lord, in a briefer response to your question, that if you were to find against us on point 1, whether there's an agreed fact, do I still have an argument in relation to the remainder? We submit we do, but clearly I have a higher hurdle to overcome.
Thank you.
Follows. Thank you.
We're going to stop now. I know
Great.
at 5 to 1, and we'll start again at 2 o'clock.
Thank you, Miles.
All rise, please.